And so for everyone, I want to express my appreciation to Judge Tucker for agreeing to chair both this meeting and the quarterly commission meeting. I think we're waiting for Judge Daly and Representative Krajewski. I don't see them on at this point. And I know that the Senate apparently is in session today. Senator Street, I see someone from his office is on, but the senator might be in session, and that would also apply to Representative Langerhold. But we do have Judge Marsica, Attorney Marsico, and Professor Rago, District Attorney Sunday, and of course you, Judge Tucker. So I think we have what we're going to have to get started on the policy meeting.
Okay. So I believe our first item would be the overview of the comprehensive review of the sentencing guidelines.
That's correct. And for the members and for the public that are joining us, the document that we're going to be talking about was provided to members last week, or I guess last week, and it has been posted on the website. So the title is Second Comprehensive Review of the Sentencing Guidelines. During the policy meeting today, Dr. Kleinman and I will provide an overview of the issues that are sort of in play under this comprehensive review. And then later in the policy meeting, we'll ask Christy and Ryan to talk a little bit about our web-based application, SGS Web, because although the policy effort is all around changing guidelines, when it comes to implementing the guidelines, it's really important that we have a mechanism in place to both calculate guidelines and also provide for the reporting of sentences to the commission. And that application we've had for many years now. It's called SGS Web, Sentencing Guidelines Software, and it's based in JNet, and it's available to all authorized users at the county level. But it's really important when we think about changing guidelines that we also think about changing the mechanism for courts to be able to determine the guidelines and to report sentences to us. So Christy will talk a little bit about some of the efforts in that area, sort of a parallel track. And then if time permits at the end of the policy meeting, we'll just talk about the other issues. So Dr. Shoup and I will discuss some legislation that's pending that would have an impact on the commission and any other issues we have time for. But as the judge said, we'll start with Matt and I talking a little bit about this comprehensive review of sentencing guidelines. And I'd like you to think about my part of this as providing a little bit of background on guidelines generally, and then some background on the process we've been undertaking since 2014 to do a comprehensive review of the guidelines, to come up with recommendations that we could bring to the commission for consideration. And then Matt will sort of dive deeper into that, both talking about the work during last year with the academic review panel, and then specific recommendations that come out of that. And then we will be talking about scheduling a special meeting of the commission, and we'll have details about that later, in order to really look at the details of these proposals, to start that process. Because as you know, once the commission adopts guidelines or proposed guidelines, we then hold public hearings. And then after we complete the hearing process, the commission formally adopts guidelines and submits them to the General Assembly. So we have to get to the first step of the commission reviewing recommendations and coming up with a proposal to put out to public hearings. And we're hoping that that this starts that process, and later this year, we're in a position to hold public hearings. So with that, here are the slides. And as far as the background of the sentencing guidelines, just a little history. Keep in mind that we have sort of different periods of the guidelines. The first period was, what the commission first established in 1979, and its first job was to adopt the initial sentencing guidelines. The commission did that, and those were rejected. And so when the first guidelines actually took effect, we had an initial period I'd say from 1979 to 1986, where the guidelines were new. It was an innovation. And so both the courts, the trial courts, as well as the appellate courts, had to sort of figure out how guidelines fit into the landscape in Pennsylvania sentencing. So we'll talk a little bit about that and some takeaways from that. I have a section that we call course correction, 1987 and 1988, and it really dealt with some guidance from the Pennsylvania Supreme Court about how the guidelines do operate in Pennsylvania. And then the next sort of section of time dealt with the response to that direction from the Supreme Court, the first comprehensive review of the guidelines and the adjustments that occurred. And this is basically in the late 80s and early 90s. And that provided a basis for the guidelines. And then I'd say from 1998 forward, we've been sort of in another era where the guidelines were substantially in place, and we were adjusting them in response to legislation. So I'll take a couple minutes to talk about each of these areas, and then we'll talk about the second comprehensive review we're doing. Next slide. So that first period, the initial guideline period, as I said, in 1981, the commission adopted the initial guidelines and submitted those to the General Assembly. And the General Assembly, by a concurrent resolution, rejected those guidelines. They indicated that the guidelines were not severe enough, especially for serious and violent offenders, and they thought the guidelines were too restrictive of judicial discretion. And so the commission took that advice from the General Assembly, went back to work, expanded the duration of the guidelines by, in effect, expanding the recommendations. So we kept the initial guidelines in place and expanded the options available to the court by sort of raising the limits on the guidelines. And that way we also were addressing some of the severity concerns. Those revised guidelines were adopted and submitted to the General Assembly, and they went into effect in 1982. And then in 1983 and 1986, there were amendments to those guidelines. And in 1986, there was a second edition of sentencing guidelines. So that was that sort of initial era. And what happened during that period of time was the cases in dispute, especially about the exercise of discretion by judges, went up to the Pennsylvania Superior Court. And the Superior Court established rules of the road for reviewing cases relative to the guidelines. And during that period, the Superior Court gave pretty strong deference to the guidelines and less deference to the individualized sentencing by the court. And they created two channels of review. One was procedural, where they really focused on, did the court play by the rules? Were the guidelines calculated correctly? And did the court have the correct guidelines before it when sentencing? And then the second aspect was substantive, and that was really about if there was a sentence outside of the guidelines, were there meaningful reasons for that? And it was all about the exercise of discretion. And that's where the Superior Court was developing what was viewed as a common law of sentencing about what were the factors that were appropriate and what were factors that were inappropriate for sentences outside of the guidelines. And I should clarify at this point that when the Superior Court or the Supreme Court reviews discretionary aspects of the guidelines and they talk about something being within the guidelines or outside of the guidelines, they're talking about all three ranges of the guidelines. So in the sentencing guideline world, we have the standard range, which is the basic recommendation that you find in the matrix. But we also have an aggravated and mitigated range, sort of buffers on both ends of the standard range that expand the discretion of the court. So when the appellate courts are looking at whether a court was within or outside of the guidelines, they're talking all three guidelines collectively. And so a departure from the guidelines would be a sentence above the aggravated range or below the mitigated range. So if you keep that in mind, we had not only fairly broad guidelines in terms of our standard range recommendations, but really broad guidelines if you consider all three ranges collectively. And so that's one of the criticisms you hear over the years, that our guidelines are so broad, especially for less serious offenses, that they actually give little guidance because courts can do just about anything for especially lower level offenses, because any sentence would be within one of the ranges. So that's an issue we'll come back to. The bottom line during this period of time, up through 1986, was that we had presumptive guidelines. The presumption was the court would be imposing a sentence within the guidelines, within one of those three ranges of the guidelines. And the court would have to justify a reason for going outside of those guidelines. And it was a reasonableness standard. So the appellate courts were looking at the reasons provided by the sentencing court for going outside of the guidelines and determining if they were reasonable. And the Supreme Court did provide guidance in terms of what was reasonableness, but the General Assembly did too. And there were two sections of statute that sort of talked to what was reasonable. And these are still in statute today. They're in the appellate rules in section 9781, and they're in section 9721, which deals with the purposes of sentencing, sort of the direction courts must take. So that is the background. And through that second edition of the guidelines, the term that could probably best be ascribed to guidelines in Pennsylvania were that they were presumptive guidelines. And there was pretty substantial appellate review, both of procedure and of substance. Next slide. So here's the course correction period. In 1987, the Pennsylvania Supreme Court decided a case called Commonwealth versus Sessoms. And it didn't initially deal with the substance of the guidelines, but dealt with the procedures by which the guidelines were adopted. So the court went back to 1981 when the first set of guidelines were adopted by the commission and submitted to the General Assembly. And the court reviewed the process there and found that it was unconstitutional, because although the General Assembly was authorized to pass a concurrent resolution, so pass a resolution in the House and in the Senate to reject the guidelines, the court held that it was the responsibility of the General Assembly then to present that concurrent resolution to the governor so that the governor could act on it. And the General Assembly did not do that. So in any legislation, you present it to the governor, and the governor has the option of vetoing the bill. That wasn't available to the governor in this case with the first guidelines. And so in 1987, in Sessom's case, the Supreme Court invalidated the guidelines. In effect said, because the initial guidelines and the rejection process was flawed, any guidelines that flowed from that was flawed. So you must start over again. The commission, these guidelines are invalid, and the commission must start over again. Within that opinion, and there was a lot of issues discussed in the opinion, but within that opinion, what the Supreme Court talked about was that the sentencing guidelines were one of many factors that the court must consider. So they looked at the statute about what courts should consider when sentencing, the exercise of discretion, other things like that. And the court said, look, the guidelines are helpful and meaningful and worthwhile, but they're not the only thing. And so it's one of many factors to be considered. And so the takeaway from that was it really changed the complexion of the appellate review of departures from the guidelines. It changed some of the standards in place. I'll get back to that in a minute. But the second case that was decided by the Pennsylvania Supreme Court was in 1988 in a case called Commonwealth versus Devers. And this really dealt with what does the court have to do in explaining a departure from the guidelines. So if the court is going to sentence outside of the guidelines, above the aggravated range or below the mitigated range, what does the court have to provide in writing so that the appellate court can do an appropriate review. And up until that time, certainly panels of the Superior Court and the Superior Court as a whole was looking for detailed information for a reason for departing from the guidelines. In the Devers case, the Supreme Court said that if the sentencing judge had access to a pre-sentence investigation report, there was going to be an assumption of reasonableness. So sort of shifting the view of the review of the case, right? So instead of assuming the guidelines were right and the court and giving sort of less deference to the court, the individualized sentence, this flipped that and said, if the court has a PSI, the appellate court should assume that the sentencing judge had read and considered the PSI. The PSI is part of the record of the case. And so there will be an assumption that based on that information, that's the justification for a sentence outside of the guidelines. So the PSI itself is a presumption of reasonableness. One thing that I think it's important to think about, because we talk a lot about recommending PSIs today, but one thing to think about was during this era in the 1980s, the Supreme Court had advocated for the greater use of pre-sentence investigation reports. And in fact, they required the Criminal Procedure Rules Committee to create rules that address the use of PSIs. And at the time of the Devers decision, the court was under the assumption that PSIs were quite common and that the factors articulated in the rules were being included in PSI reports. And that may have been true at the time. But the research we've done more recently about the use of PSIs is that PSIs statewide occur in about a quarter of the cases. So 3/4 of the cases, there's no PSI. And then if you go from county to county, some counties prepare PSIs in almost every case, and other counties rarely provide a PSI. But the quality and nature of the PSI varies a lot from county to county. In some counties, what is called a PSI is really a very spare report of background on the offender. And in other counties, a PSI might be a very detailed report that includes a psychological and other kind of information. But it's only done in about a quarter of the cases. And there's a lot of negotiated pleas that do not include a PSI. The other thing is, in recent years, in the last decade or so, national research, and especially the work of the National Center for State Courts, has been advocating for really improving the quality of PSIs and including in PSIs information on the individual's risk and needs and responsivity. So case planning, case management of the case, so that the court has really detailed information about who that individual is and what kind of intervention might work best at the time of sentencing. So if you think about sort of what we talk about as PSIs today, and then what we also look at in terms of how often PSIs are prepared in Pennsylvania, it's really a far cry from what was sort of identified or assumed in the Devers case. And so it does tie into what we'll talk about in terms of promoting better and more information to the court to make individualized decisions. So the takeaways, I'm sorry, could you back up? The takeaways then during this period are, number one, there was a change in the review by the Superior Court that sees the bulk of these cases on the discretionary aspects of the guidelines. And the change was from a reasonableness standard where the Superior Court was not giving a lot of deference to the individual information or individual reasons for discretion given by the court, to the other end of the spectrum where the presumption was that if the court had a PSI, it was reasonable. That was an appropriate sentence, and the court didn't have to provide more information, and it was favored over the sentencing guideline recommendation. And that leads to sort of the labeling of the sentencing guidelines. That sort of marks the turn from our guidelines being perhaps presumptive guidelines to them being advisory guidelines, that they must be considered, but courts have great discretion to move away from it. And the point I want to make in that change is the initial guidelines, those guidelines we talked about, the first and second editions of the guidelines, were created in a time when the guidelines were viewed as presumptive. And so, to some degree, would restrict the discretion of the court and create difficulty in a court going outside of the guidelines. But that view changed when the guidelines changed from being presumptive to advisory. And it's the argument that if they're advisory guidelines, they are truly designating a starting point for consideration of sentencing. And there may be value in being much more direct and focused in what that recommendation is, because courts do have the discretion to depart from the guidelines. There's sort of a liberal view of the exercise of discretion. And further, if the court does have a pre-sentence investigation report, then Devers is still good law, and it basically says that that is in and of itself justification for a decision by the court to go outside of the guidelines. So some big takeaways from this course correction time that applies certainly to our review of the guidelines today. Next slide, please. So we're going to move into the next era of the guidelines. We come off Devers and Sessoms. The court has to, the commission has to redo the guidelines, has to start again with a review of the guidelines. And so they go about, in effect, reenacting the guidelines with some changes, but in effect, taking the guidelines that had been in place, readopting them, and we come up with the third edition of the guidelines in 1988. And so those are restated, and there's a minor change in 1991, because at that point, the General Assembly has created a new sentencing alternative called County Intermediate Punishment, and a new program called the State Motivational Boot Camp. And so the 1991 guidelines or revisions incorporated those into the guidelines. But in effect, the guidelines were the same as the second edition guidelines. They were just reinstated. But the commission had already started a comprehensive review of the guidelines. And the reason they started that was in 1979 or 1981 or 1982, those early years, there weren't many other jurisdictions that had sentencing guidelines, certainly not statewide sentencing guidelines. Pennsylvania was the second state to have statewide sentencing guidelines, following Minnesota. And so we were in the vanguard, and there were a lot of questions about whether the guidelines were appropriately structured, or what the impact of the guidelines were, or whether they were meeting the purposes to promote uniformity and proportionality. And so the commission in the late 80s had started to do this analysis of all sentences imposed under the guidelines as part of this comprehensive review of the guidelines, and to look at changes in statute and case law and trying to figure out what should the guidelines look like? How do we promote better practices? And what was really key, and especially in the early 90s, was consideration of alternatives to sentencing and consideration of the use of clinically prescribed treatment to address drug dependency. So a lot of those kind of issues were in play. So when the commission undertook this first comprehensive review of the guidelines, it was with sort of an eye towards reviewing what had happened, sort of lessons learned from other jurisdictions that now had guidelines, and incorporating better practices. And so you saw this reflected in the 1994 and then the 1997 guidelines. The 1994 guidelines really were the sort of switch point. That's when we moved from the first era of guidelines to this new era of guidelines that really focuses on trade-offs with treatment and other things like that. But there are a lot of other things in the fourth edition guidelines that were important to consider. Up until that point, we had, in effect, two separate guidelines. One set of guidelines for crimes code offenses, and a separate set of guidelines for drug offenses, drug violations. And so not only was it complicated because you had two sets of guidelines, but it was also sort of from a policy point of view, it was difficult to sort of think about how one set of guidelines compared to the other. We weren't like thinking about how does this drug offense sort of fit into the ranking of offenses in the crimes code. They were just like on two separate paths. And so the idea was to combine everything together, come up with a more uniform set of offense gravity scores that address both crimes code offenses and drug violations and any other kind of violations that would come before the court, DUI, vehicle code, other types of crimes. So the idea was to, sort of rebuild the guidelines that covered everything in a uniform way. That's when we adopted a matrix. So the matrix we have in place today sort of goes back to the fourth edition guidelines where we created that matrix. We also, during these guidelines, looked at the serious and violent offender category and decided to create two special prior record score categories, one for repeat felony 1 and felony 2 offenders, and the others for repeat violent offenders. So those were big takeaways from this period of time, the 1994 guidelines. In 1995, Governor Ridge called a special session on crime. And there was really a redrafting of criminal codes, especially around violent offenses and sex offenses. And so the commission during that period of time revisited the work of the fourth edition guidelines and modified it to address the changes, which were pretty substantial from the special session on crime. And the result of that was the fifth edition guidelines in 1997. And a couple of takeaways from that I think are really important for consideration today is that the commission did a couple of things. One was it changed the nature of the guidelines. Up until that point, the guidelines were built around almost a case management system, but it was a grouping of offenses called transaction. And although there were problems with the definition we had, the idea was we should look sort of at a criminal incident or an event, and we should be coming up with recommendations that are sort of holistic to that event. And because of that, when we were coming up with recommendations under those earlier guidelines, we would determine the offense gravity score for each conviction offense in that incident or transaction. But the prior record score would only apply to the most serious offense. All the other offenses in that transaction would have a 0 prior record score because the assumption was you're applying criminal history prior record to the lead offense, but all of the other offenses, there's no need to do that because you've already accounted for criminal history in that lead offense. And the other offenses, you're just looking at the impact of that offense. And so it really did contain the weight we would give to a prior record score. That was removed though in 97. And the reason was there was a sense that the court should move to an offense-specific consideration. And when they do that, then the court should exercise their ability to sentence concurrently or consecutively, which would help contain the weighting of the prior record score. Because at the time, there was not only the assumption that courts generally impose sentences concurrently, and especially within a transaction or an incident, but there was also a rule of criminal procedure that presumed the sentences were concurrent unless the court stated otherwise. Now, ironically, at the time the commission was working on the guidelines, the Rules Committee was looking at that rule and saying, it matters if a court says concurrent consecutive. So instead of having a default where we assume it's concurrent unless the court states otherwise, we're going to change the rule to say, in every case, the court must state whether the sentence is to be served concurrently or consecutively. And the consequence of that was a broader use of consecutive sentences. So at the very time that we added prior record score to every offense and thought that it would be contained through concurrent sentencing, there was an expansion of consecutive sentencing. So that expanded, that contributed to, a lot of other things did, but that contributed to an increase in sentences, especially for violent offenders. That might have been consistent with the policies at the time, but it was something we wanted to review as we were looking at these guidelines. Next slide. So this is just a quick example of the earlier guidelines and the more recent guidelines. On the left, you'll see that there were two different grids that were used to determine sentence recommendations. The one on the far left was the crimes code, a 10-point set of recommendations. And then the other one, the alphabetical one, was for drug offenses. And it went through A to N, and in 1991, A to M, and then in 1991, we added another category, N. So it was a pretty complicated system then. The idea in 1994, 1997, and thereafter was moved to this more consolidated matrix where everything was considered on the same scale. Next slide, please. And so now we're in the modern era, 1980, 98 to present. And we've had a lot of guidelines. In 2005 and 2008, we had the 6th edition guidelines and revisions. And then starting in 2012, we had the 7th edition guidelines, and we have done a lot of amendments to that. You know, we're on Amendment 6, and aside from the 6 amendments, we also had a supplement, right? So we have changed these a lot. And one of the reasons we've changed them is that the General Assembly has moved towards looking to the Commission to build into the guidelines enhancements that address certain factors at sentencing. And we now have approaching 20 enhancements, but at least 14 statutory enhancements that are built into the guidelines. And even today, we'll be discussing, you know, a change to an enhancement and a new enhancement that's legislation that's moving through the General Assembly right now. So one of the things that has happened during this era is the Commission has become much more detailed, much more engaged in looking at elements and factors at sentencing and using those to come up with very specific sentence recommendations. So it's a much more complicated system that we have. There is also, coupled with that, the need to automate this process. And so we've done a lot of work over the years in automating the guidelines. And one of the things that is a consequence of automation is at the time that someone in the county is preparing a guideline form, they need a specific offense gravity score for any set of circumstances that leads to a conviction. So the Commission really had to go micro, had to really come up with specific OGS assignments for each and every circumstance based on the elements of the crime or the grading of the offense. And so a lot of things have happened positively in terms of getting that granular, that detailed on the offense-related information to come up with recommendations that are specific to that offense or the nature of that offense, and also allows us to sort of connect that information to charging information, to commitment information at DOC or placement on probation. So we have worked closely with the Administrative Office of the Courts, the Pennsylvania State Police, the Board of Probation Parole, and the Department of Corrections in coming up with consistent codes that we could use to sort of share information. And that has really helped to integrate a lot of what we do and allow us to analyze outcomes, you know, what works and what doesn't. But it also added to the complexity of the information we have in the guidelines and the information we capture in our SGS web application. So So that gives you a really high level view of sort of the stuff that we've seen in terms of the guidelines. And now what we want to do is talk a little bit about what have we done to study this sort of second review of the guidelines. Remember, we did one in the early 90s, late 80s or early 90s, because guidelines were new. Now we're doing it because, there's been a lot of changes, a lot of legislative changes and case law changes, but also a lot of other mandates on the commission, not only with sentencing, but with things like resentencing guidelines, parole guidelines, recommitment ranges. So we want to take full advantage of all of that in rethinking the guidelines. And we also want to take into account the benefits that can be derived from the court having better information, both information on the seriousness of the offense and the person's prior background. We call that sort of retributive factors. But we also want to look at risk-related factors, public safety factors. So risk, needs, and responsivity. How can the court best deal with a case to promote better outcomes for the community and better outcomes for that individual? So we want to try to harness all that information, take full advantage of it in a rebuilding of the guidelines. Next slide. So here's what we've done. Since 2014, we've taken 3 key steps, and you'll see other parts of this, but to try to review the guidelines. The first thing we did was from 2014 to 2016, we conducted a strategic planning work group. Recommendations came out of that group. We then reviewed those recommendations with subcommittees of the commission to vet those, to modify them, to add provisions. And then we were engaged in a number of structural changes. Think about legislation that was enacted, Justice Reinvestment Initiative, other things like that. So let me quickly go through these, and then I'm going to turn it to Matt to talk about the specifics. So in 2014, the commission established a strategic planning work group. And the idea was to bring together people outside of the commission to do sort of an external review of the guidelines. And what we found from this group was that there were a lot of sort of guiding principles if we were going to rebuild the guidelines. We should streamline the guidelines, simplify the guidelines, increase certainty, so have much more focused guideline recommendations so that both parties and the defendant have a clear understanding of what the recommended typical sentence is, and that can be used in terms of negotiating or discussing the disposition of the case and the duration of the sentence. We also wanted to talk about things like the effective and efficient use of all correctional resources. What's the right fit? What's the right duration of probation? What's the right duration of confinement? When's state prison better than county jail, and so forth? So the recommendation through that group was to greatly increase the number of offense gravity score categories from 14 or 15 up to 48, and to use those to promote more uniformity and proportionality in targeting. To reduce the impact of the prior record score, and especially through removing stale records, and to create adjustments within the guidelines so that we could automate things like those enhancements. So it was more simplified, that you had sort of a base assignment for an offense, and you'd adjust that assignment based on what may be viewed as aggravating or mitigating circumstances. And that could include enhancements, it could include an inchoate offense, it could be other factors like that. Next slide. When the commission received the strategic planning work group report, they then impaneled 3 subcommittees, one that focused on offenses. So think about offense gravity score. Should there be 48 categories? Offender, think about prior record score or other offender related issues. And then just sentencing policy. And think about, in that case, the Justice Reinvestment Initiative, or the more current discussions of caps on probation or other things like that. So these were the 3 areas that we looked at. For the offense-related one, the subcommittee recommended reducing from 48 down to 36 offense gravity scores, and building into that system aggravated and mitigated circumstances. For the offender-related subcommittee, there was a lot of work looking at how prior record scores work, how they relate to risk of reoffense and things like that. But we also benefited from work and partnership with two academic institutions. We worked with students and faculty at Carnegie Mellon University to look at ways of reducing complexity and really digging into issues of recidivism and categories of prior record score. And then with Drexel Law, we worked with students and with a commission member and faculty member there to really dig into the lapsing provisions, which offenses should go away and when and how and so forth. So a lot of good, helpful information there. And as I said, the policy committee coordinated and participated in the Justice Reinvestment, the second round of that. And there were a lot of takeaways, both recommendations from that JRI working group, as well as legislation that flowed from that. Next slide. And so here are the sort of the concrete deliverables. Here are the structural changes that have resulted from those earlier reviews. Starting in 2018, there was Justice Reinvestment 2. The working group provided us with recommendations in 2018, which really addressed that targeting and the reduction in the prior record score. And then legislation enacted as part of Acts 114 and 115 of 2019 did things like require the commission to create probation guidelines and allow the commission to incorporate into the guidelines things like risk and needs and responsivity. And importantly, authorize the commission to reduce or lapse prior convictions. Under our enabling legislation, the commission is required to consider all prior adjudications and convictions, and that is what the prior record score is. But JRI 2 gave us authority to eliminate or reduce some of those, to reduce the value of prior record score in the sentence recommendation. So that was an important advance. For sentence risk assessment in 2020, the commission was mandated to create a risk assessment. And one of the key outcomes of that was the commission decided to use risk assessment to identify when the court should have additional information to make decisions at sentencing. So this was greatly informed by public comment we received, concerns about increasing sentences based on risk, general risk applied to an individual case. And what the commission came away with was an understanding and an appreciation of the value of information on risk, needs, and responsivity, and making sure that information was available to the court that could help guide the court in deciding how to impose a sentence. So that's been built into our guidelines. But this gets to that issue that was raised in Devers about giving the court good and useful information to make better decisions at sentencing. And because the court could rely on a PSI with this information, the court can sentence outside of the guidelines without much of a fear of being remanded, because the report itself is a justification for a sentence outside of the guidelines. And then finally, last year, and then it took effect early this year, the commission adopted an amendment to the 7th edition guidelines, the 6th Amendment. And here we implemented some of the legislation we were mandated to consider. We incorporated probation guidelines into the sentencing guidelines. We incorporated guidelines for the use of restrictive conditions of probation, what previously were called county IP sentences. But maybe more importantly, and sort of hidden, is we refocused the purpose of the guidelines. We tried to identify the importance of considering risk and needs and responsivity, the importance of considering other information at sentencing as reasons for departures from the guidelines, and the importance of risk, needs, and responsivity generally. So those are all built into the guidelines. With that, I'm going to turn it over to Matt so that he can talk in more detail about sort of the last part of this structural change under this review of the guidelines, and that has to do with our work with an academic review panel. Matt?
Thanks, Mark, and good morning, everyone. I think that Mark's presentation really establishes a foundation to show that this effort of reconsidering an 8th edition has been built on all the prior work, starting with the origination of the guidelines. But I think for purposes of this discussion, really the work that he just highlighted, be it by the strategic planning work group, the subcommittees that were done, the JRI2 initiatives, and as Mark noted, some efforts where we're thinking about automating, providing the court with better information at the time of sentencing, use of risk needs responsivity, and really that assessment showcases to the complexity of the current guidelines, as Mark mentioned, and we'll get into some detail about this, just the numerous enhancements and how the guidelines work in practice, how prior record score is considered, and so forth. So over the last few months, starting in the fall of 2020, an academic review panel was established with Judge Tucker as the chair. And that review committee was made up of 11 members. 7 were professors here in the Commonwealth, and then we had 3 professors from universities in other states, and we had a retired member of the United States Sentencing Commission to inform us. And these were all experts in the area of guidelines, juvenile and criminal justice, social justice policy, race and ethnicity, to bring a real unique focus holistically about all of the different moving parts, and to really bring an eye towards proportionality, fairness, and some of the issues facing us with race and social justice as well. We also had the benefit of being joined at some of our meetings by 3 guests. Or 4 guests, actually. We had the executive director and the clinical director of the Sexual Offenders Assessment Board. We had the director of policy and legislative affairs from the Department of Corrections. And we also had the executive director of the Juvenile Court Judges Commission join us. I should note also that the summary of this academic review panel could be found in the summary document beginning on page 8. And later in this presentation, I'll be referring to the proposed sentencing matrix, which can be found on page 17 of that same summary of the 8th edition guideline document that Mark mentioned at the beginning. During this time period, we met 11 different times for roughly 2 hours a session. So a tremendous amount of work, a tremendous amount of effort was put into this. And just like to thank all of the members, specifically Judge Tucker, but then all of the members and our guests who were part of this group to invest so much time in this process and to work with us to it was an iterative process where each discussion led to the next discussion, which built upon, again, the work of the strategic planning work groups and those subcommittees to bring us what I think is a good starting point of a proposed draft of a new set of guidelines that I'll be outlining some of the process and some of the decisions that went through those 11 meetings. So the group itself was brought together to discuss the systematic changes needed to address racial disparity, and also, as Mark noted, to incorporate evidence-based practices. We wanted to consider how, well, to begin, one of the earlier sessions of the group was to showcase what the proportion of white offenders and minority offenders, of how they array currently on the guidelines. And what we saw is that the proportion of white offenders decline as you move higher on PRS and higher on OGS. Secondly, we wanted to think about new evidence-based practices, and one of the examples and how science can inform the need for change was looking at juvenile adjudications and their role in the guidelines, specifically prior record score, and advances in brain research certainly informed our discussion, and I'll return to that later. But overall, and Mark noted many of these already, was some of the goals were to simplify the guidelines, to automate them, and we'll have a presentation later that will draw this linkage between the new version and what we're calling the next generation SGS web application. And based on those JRR2 recommendations, to reduce the impact of the prior record score. So for a guideline sentence recommendation, the benchmark for judges of Pennsylvania, a common starting point with a range of recommendations for the typical offender, the guidelines should provide sanctions proportionate to the severity of the crime and the severity of the offender's prior conviction record. This establishes a system with a primary focus on retribution. This also goes on to continue that it allows for the fulfillment of other sentencing purposes, including rehabilitation, deterrence, and incapacitation. I note this because our strategic planning work group spent a lot of time discussing the purposes of sentencing, specifically when we're focused on looking at the role of prior record score, but also in framing discussions about the purposes of sentencing in general. And one of the continuations or extension of that our group really highlighted was thinking about the goal of restoration, highlighting a really strong desire for increased resources to support community-based programs as alternatives to incarceration, and including the providing hope as a component of these alternate programs. Again, consistent with some earlier themes is a desire for additional information to be made available to the court prior to sentencing to ensure the individual nature of the sentence. One example was that the group recommended that assessment reports be provided to the judge prior to sentencing that are prepared by the Sexual Offender Assessment Board. And this group also spent a lot of time focused on thinking through the role of juvenile adjudications at sentencing, specifically their contribution to prior record score. A starting point for this conversation is to just quickly take a look at our current basic sentencing matrix. The current matrix has 14 OGS categories. That's the vertical axis, and it has 8 PRS, prior record score categories, which is our horizontal axis. And those stair-step colored regions represent our 5 different sentencing levels, which would be the presumptive recommendation for a sentence type such as county incarceration, as an example. Has been noted that the ranges, these are what the values here are the standard range, and oftentimes we would see a range that are pretty wide. And for example, if we take the intersection of OGS 5 and PRS 0, we see the standard range as restorative sanctions up to 9 months of county incarceration. Also, we see the P2 recommendation of 2 years of probation, and we see additional information as well. So there's a whole host of different sentence recommendations and durations that are involved in this. So one of the focuses of this group was to think about tightening those ranges. And then in this current construct, if you look at the lower limit of the standard range for when prior record score is 0, and then you would go across the prior record score, you could see that the impact of prior record score is pretty significant. We could see an increase of 5 to up to 9 times the duration of when prior record score is 0. So these were a number of starting points for our academic review panel. This is the proposed matrix that came out of the work by the academic review panel. So I realize it's really tiny, and it can be found again as attachment 3 on page 17 of the summary of comprehensive review documents. The defining characteristics here are we have 40 offense gravity score categories. We have 4 prior record score categories and 6 sentencing levels. So in the time that I have remaining, I'm going to walk through some defining characteristics of the changes. One thing to note is Mark also alluded to a special policy meeting that we hope to convene in July. And that will be the opportunity for us to really roll up our sleeves and start looking at specific elements related to this. So my summary will be at a higher level, really just defining some of the descriptive elements of the changes between the 7th edition basic matrix and this 8th edition, and some of the value added by adopting or considering an approach like this, and how it meets those goals of simplification, automation, and reducing the impact of prior record score. So just for visual and through this presentation, I've cut the matrix, the proposed matrix, in half, so that the left side here is levels D through E, running from state incarceration with a county incarceration exemption all the way up through level F, which is including juvenile and adult murder 1 and murder 2, and then the matrix on the right, which is just the bottom half of the proposed matrix, which runs from level A through C of restorative sanctions and county incarceration. So I will be using these reduced or minimized sections of the grid for examples, but recognize that the grid itself is what we saw earlier, this giant vertical matrix with the 40 OGS categories. So some of the defining characteristics of the prior record score scale, again, we move from 8 categories to 4. And I'll speak more about that in a moment. We retain REVOC as a category, and that's our, in the current definition of repeat violent crimes and having an OGS greater than or equal to 9, but essentially our repeat violent offenders, preserving that. But one of the advancements here is we introduced a range of sentences up to the statutory maximum, as opposed to solely including on the matrix the statutory limit, giving a little more guidance that a range that judges can work at for a standard range of their sentencing. A big innovation is moving from a point-based system to a categorical system. And this classification into these categories of low, medium, high is based upon the highest statutory grade of the prior convictions and consideration if there are multiple priors of that same type, or if there are more than one victim involved in those prior convictions. Again, that detail and the mapping of that we could get into in more detail later today, or certainly will be a topic of conversation for that special session in July. But when we worked with the group, the academic review panel, we considered again the complexity of the current assignments in the basic matrix as it exists now. Under that point-based system, we have combinations of scoring of different prior offenses that lead to potentially situating different combinations and treating them the same. So for example, an offender convicted of 7 prior misdemeanor and an offender convicted of a prior ag assault attempting serious bodily injury, both of those scenarios would receive 3 points. Under our current system, if their most serious prior conviction was a misdemeanor, as opposed to their most serious prior conviction being an ag assault attempting serious bodily injury, they would be treated differently. And I think it provides for, again, simplification, but it also relates to automation. And I should mention that when we're dealing with out-of-state convictions, that this new framework also provides a much more consolidated, parsimonious way to assign those to our prior conviction or prior record score categories. We also, as I mentioned a couple times, thought a lot about juvenile adjudications. We were fortunate to have 2 experts on our panel related to juvenile justice. And as I mentioned, we had also a visitor or a guest from the area of juvenile justice. And we introduced separate policies to minimize the impact that juvenile adjudications have on prior record score, when they're counted and how they're counted. We also have introduced preliminary provisions for adult offenders for these gap policies. As Mark mentioned, prior work done by Drexel University highlighted the role of stale criminal records in the current prior record score, so we built off of that component. Probably the most important of the concepts here is that the primary driver of the sentencing recommendation for this current configuration is OGS. As I mentioned in the overview of that basic sentencing matrix, as you go across prior record score, the impact of that can be many times the magnitude when compared to when prior record score is 0, up to almost 10 times as much. Our group really talked about reducing the impact of prior record score. And as a guiding principle, we have for the low, medium, and high, that medium is 1.5 times the amount of low, and high is twice the recommendation of the low category. And as you see on, if you were to look at the proposed grid that we include on page 17, many times, in fact, the impact of the prior record score is even less than what these base recommendations are. Certainly, again, that's something for consideration when we discuss this in July. But I also think that one of the components here is to think about how to potentially include some of the aspects of prior record score that are currently included in prior record score into classifications on OGS. So for example, if we had a second subsequent offense, rather than treat that as a component of prior record score, we could accommodate for that in an adjustment upward of an OGS assignment, utilizing our 40 OGS categories to increase the sentence recommendation rather than to embed something like that in our prior record score. One last point about prior record score is, again, the academic review panel spent a lot of time talking about the purposes of sentencing and what role that prior record score should play in this. Some of that is reflected in that magnitude of that final bullet. Staff spent a lot of time looking at risk levels to see if there was a step up as we moved across categories. That Carnegie Mellon study that Mark referenced found that there was very little differentiation between many of the prior record score categories in the current configuration of prior record score, so that categories such as 3 and 4 have the same levels of recidivism for offenders who fall within 3 and 4. So we spent a lot of time thinking about it through the lenses of retribution, again, restoration, and as well as risk. Switching over to the offense gravity score, the new configuration shifts from 14 categories to 40. And I'm going to talk about some of the components of offense gravity scores, specifically about offense gravity score, but it's difficult to talk about offense gravity score and prior record score independent of one another. So many of the discussions here will relate actually to the intersection of offense gravity score and prior record score as it relates to the grid itself. But one aspect of increasing the number of OGS categories is it allows for a granular OGS assignment process. with 14 OGS categories that currently exist, some offenses are included within those OGS categories that may in fact be a little bit different. And the third bullet gets to some of that as well, which is the current matrix includes very wide standard ranges, maybe to accommodate for the fact that there are different offenses that are not actually similar within those OGS assignments. So the current expanding to 40 will allow for individualized sentencing and judicial discretion, but I think a more refined, nuanced, precise assignment of these offenses to the OGS categories. It's also important to note that we will define a typical sentence as the median sentence imposed for an offense based on the elements and sentencing factors identified by the commission. Staff have already begun working on calculating these median sentences for the low or prior record score 0 categories to begin to think about how we would assign offenses to these OGS categories. So this is a very descriptive approach, which is based on historical sentencing practices. We hope to bring that information to the policy meeting in July to allow for a prescriptive approach as well, which is looking at those specific elements and factors as well as the offense types to help us assign specific offenses to these OGS categories that will continue to ensure proportionality and of the different types of offense categories. And then the last bullet here, I've already mentioned that it allows for us to consider or think about previous convictions and treating them and utilizing the OGS assignment rather than thinking about that through the PRS categories. And this will help, again, simplify and allow for automation of both PRS and OGS assignments.
Hey, Matt, if I could just insert a comment there. In terms of that, those prior offenses being used, we're talking about those situations where, as an element of an offense, a prior conviction increases the grade of that. And that's a really, one of the reasons for taking out of the prior record score is the grade of the offense is different, the factors are different, the elements are different, and we usually look at elements of a crime and the grading of the offense to come up with the OGS assignment. So by moving that over to the OGS category, we then remove that from the prior record score, and prior record would be linked to other previous offenses, not offenses that are the same or similar to the one for which the person is presently convicted. I know Matt has about 15 minutes to go in terms of talking about the sort of how this all comes together with the sentence recommendation. So I'll turn it back to him.
Great, thanks, Mark. So a couple defining features now about this intersection, if you would, of the OGS and PRS, so more focused on the grid than looking solely at OGS or PRS, is the current proposed matrix includes specific sentencing recommendations for restorative sanctions. So we've expanded the number of cells that are related to this level A to include both community service, fines, and probation recommendations within those specific restorative sanction recommendations. We've also increased the number of OGS categories within each of the sentencing levels with fewer overlaps in sentencing recommendations. As I mentioned earlier, if we were to look at on the current matrix for OGS 5 and what would be the first column there, PRS 0, we see that the recommendation there is restorative sanctions to 9 months. If we look over in, as an example, in the light green area, let's just say OGS 6, we see a recommendation of 24 months of probation. So we've removed some of the overlap in sentencing types And we also, as you'll see in a moment, we provide specific recommendations. And if you look up even to the county incarceration levels in the dark green area, you see narrower ranges and again, less overlap. There's just specific recommendations here about county incarcerations as opposed to those cells being restorative sanctions all the way through in county incarceration. The new matrix also provides explicit recommendations on probation and restrictive conditions and the duration of probation. So if we look in the light green cells again, all the way at the top or in the middle, let's say OGS 6 in the medium, we see the recommendation for 24 months of probation or 3 months of restrictive conditions of probation. Likewise, we include the duration of restricted conditions in probation in lieu of county incarceration. So we're making explicit recommendations on the new grid that don't currently exist in the current matrix. So when we look in the dark green area, we're saying the standard range for county incarceration is 4 to 6 months, for example, at OGS 12, low PRS, or that same duration of restrictive conditions of probation to account for the fact that restrictive conditions of probation can be used in lieu of county incarceration. Okay, so just to slow down for a second, 2 elements again that we've added here is we've provided specific recommendations on the restorative sanctions. And you could see we've created narrower ranges or more specific recommendations. There's not those overlap of sentencing recommendations within the cells. And we've defined here recommendations related to restrictive conditions of probation. An additional element that we've added or factor here is a sentencing level F. Sentencing level F incorporates juvenile and adult murder 1 and murder 2 into the proposed sentencing matrix. Currently, there is a separate matrix for murder of 1st or 2nd degree, and we're thinking in terms of simplicity and removing some of these extra matrices that individuals have to refer to. And I think one of the values here is you could see it steps up based on the sentencing recommendation of the standard range, so that we're, for example, at OGS 35, which happens to be murder 2, and it is the recommendation of 240 to 360 months. You move up, it's murder 1 under specific situations, 300, etc., moving up in these matrices and just making it simple, a lot simpler and easier to automate this component. Another element that we think is an improvement here is on the aggravated and mitigated sentences. Currently, we have aggravated and mitigated sentences being an addition or subtraction of months from the standard range. Here, we're proposing a step up or step down approach. So, for example, if there are aggravated or mitigated elements, or we could move up or down one OGS category to accommodate for those increases. Again, this will improve consistency, be a lot more transparent, I think, in what that standard range might be related to aggravated and mitigated sentences. Mark noted that we've had to deal with a lot of enhancements throughout the history of, in recent times, for the sentencing commission. Some of these enhancements are accommodated for in separate matrices. Like, for example, this is an illustration of an enhancement for possession of a deadly weapon. And we see that there's a separate grid here that can be utilized that retains the same 1 through 14 OGS and the prior record score of the basic matrix that's currently in practice. We think that another approach would be to accommodate for this by using, again, a step up or step down, in this case, a step up approach to handle or accommodate these enhancements utilizing our broader set of OGS categories. So one could imagine that you might move from 18 to 20 of an OGS assignment, or 18 to 22. And this is some of the, where we can use our descriptive approach and our prescriptive approach to make these assignments for what those type of enhancements might be. Similarly, we can utilize these broader set of ODS categories to consider other factors such as inchoates, and utilize the same approach of looking at median sentences for offenses, for example, where it was an inchoate offense, and classify those onto our current OGS assignments with the broader set here for a more precise starting point for judicial decision making. So, has been alluded to several times, a lot of these details, we thought that for this preliminary discussion that Mark's history would really provide a background of why we're coming at it and rethinking the 8th edition, and how did we end up where we were with the 7th edition and the 6th Amendment, where we are with current practice. And a lot of changes, as Mark and I've mentioned, the number of enhancements, special considerations that need to be made, rethinking the impact of prior record score, all of that prior work done by JRI2, the strategic planning work group, the subcommittees, really provided our academic review panel with a tremendous amount of information. And I should just note that the original conceptualization was we were going to do 3 meetings of the academic, or 4 meetings of the academic review panel. As I noted, the members graciously accepted and were willing to meet 11 times because this is complicated. And we didn't think that we could discuss all of this in 2 hours here. So we thought best if we have a special meeting on July 7th. We'll run from 9 a.m. to 4 p.m. at the Capitol Complex, where we really can roll up our sleeves and dig into these extra special elements and think about prior record score, what our definition of low, medium, high is, those OGS assignments, and so forth. So before I turn it over to Ryan and Christy to talk about all
Matt,
I'll ask Mark if he has any.
thanks. Yeah, if you could back up the slide, please. Just a heads up. Well, first, thanks, Matt. That was great. It's a lot of material, but I think you gave the highlights that are really important for the commission's consideration. Just talking a bit more about what we intend during the special policy meeting. The idea that the chair and vice chair and Judge Tucker suggested was because there's a lot of details we have to look at just to understand the recommendations, we need a full day to go into this. And so what we're thinking about is, taking, sort of an hour at a time and just like diving into some of the details in different areas. So as an example, with the offense gravity score assignments, Matt was talking about, let's look at the median sentence. We might have an offense for which we had several hundred sentences imposed during 2019, 0 prior record score. So no prior record, just, here's 100 or 200 sentences imposed. We can look at the midpoint of that and say, well, that's sort of a typical sentence. Let's see how that would fit into the new matrix. And then we have discussions around, does that make sense? Does it have to be adjusted to some degree? So I think that's the difference between descriptive, where we're using data to sort of point where we would plug in this offense, versus prescriptive, where the commission is bringing views of the case and other things like that to it to decide if there's a better fit. So that's sort of the issue that we discussed during the OGS assignment. We can also think about what are factors that are common, either aggravating or mitigating factors, enhancements, or things like inchoate offenses or different burdens like bodily injury versus serious bodily injury. Are there rules of the road that the commission can adopt that would say anytime, this is the base assignment for this offense. Anytime we see this, we adjust it up or down by 1 or 2 points or whatever might be the case. So we can again use sentencing data to help describe what the practice is right now, and then have the commission discuss whether that's appropriate or there should be any kind of change. So that's the whole offense gravity score process. For the prior record score, Matt put out a framework that we developed with the advisory committee. But you're going to find that there are, other things that are under consideration that the commission will have to think about. For instance, should there be a pure 0 prior record score category, someone who has no priors, instead of blending those individuals with people with relatively minor prior record scores? Should we move that REVOC category, eliminate it, and blend it into the OGS assignment? So there's those kind of adjustments to the prior record score policy to discuss. And then the analysis that staff's doing in terms of, well, what would it look like? Like under this model, how many people would be in each of those categories, or what percentage of cases would be in each of those categories? What's the recidivism rate by category? What's the racial impact by category, or the gender impact by category? So there's a lot of that kind of analysis that we have been doing and that we'll share with the commission. And then finally, on the sentence recommendations, trying to look at, what is the typical sentence? What is the recommendation we bring to that? But what about the ancillary issues? What about concurrent versus consecutive sentences? What about other recommendations we should be making, whether it's outside of the guidelines, like recommendations to the Rules Committee about PSIs, or recommendations to the General Assembly about legislation in terms of providing information to the court on SOAB reports? There's a lot of those kind of things that get to the general recommendations we're making. So a lot of work ahead. You can appreciate that we need a lot of time for that, and we want to have a good starting point for this review by the commission, because nothing has been adopted or approved for the public. We're just giving you what we think is closer to a full proposal for you to consider part by part and as a whole, and help us move towards adopting something or approving something that could go to public hearings later this year. What we're going to do now is switch to the other aspect of our effort. And this really gets to the sentencing guidelines web application, SGS Web. As I said at the start, we can develop new guidelines and new policies around that, but we have to think about how we implement that. And our tool for implementation is SGS Web. And it involves both how the application is used to calculate sentence recommendations and then the reporting of sentences to us. And as part of the policy discussions, we have been talking about simplification and automation to make sure that this application is as automated as possible. Because you see 40 categories of OGS and all of this other stuff in play, it looks complicated, but computers can help. And one of the things is we need the rules of the road that we can build into programming to make sure that we harness information through the system to simplify the process and automate as much as we can. And to talk about that, both sort of where we are in terms of the good, bad, and ugly about SGS Web as it exists, and to talk about sort of the vision moving forward and the work we have to do to get there. Christy and Ryan are going to give us a presentation on SGS Web. And one of the things I think that's really important to think about is how we embed this within SGS Web, make it available to users, and how we need to have decisions on the policy side, like what are the new guidelines going to be looking like, in order to build that into SGS Web. We can't rebuild SGS Web without knowing what the new guidelines are going to look like. So you can see how these are complementary things, sort of on separate tracks. And we wanted to spend about a half hour giving you this sort of view of SGS Web as an important part of this process. So I guess, Christy? Yes, Judge.
Mark, before you do that, I just want to say thank you so much for that detailed history. I mean, it was so much information that you compacted into the time that was spent, but it was very valuable, especially to a new member of the committee like me, having been involved in sentencing for a substantial period of time. You just gave it a different perspective, and I'm certain that other members of the commission would echo my thoughts, as well as members of the public, as well as the information presented by Matt as well. Just such a well presentation, because it was a lot of time, a lot of effort that went into this. We walked into this thing thinking that we can do it in 2 or 3 meetings, and realized that no, this is going to take substantially much more time to have a meaningful effort. So again, thank you very much for that, for those presentations.
Great. Well, thank you, Judge. And as Matt said, thanks for your leadership. That the Academic Review Committee, I think, to your credit, we signed them up for 4 meetings and they stayed for 11. So we appreciate all of your efforts in guiding that process. So with that, I'll turn it to Christy and Ryan to get us started.
All right, thanks, Mark. First of all, I wanted to say, you mentioned with all those OGSs, it looks a lot more complicated, but when you start talking about the step up, step down approach, like that is so much simpler than what we have implemented in SGS Web today. So I'm excited about that. So if we can make that part of it happen, I vote for that. So since not all of our commission members are super familiar with SGS Web, we're going to start with having Ryan give kind of an overview of the application itself. And then we're going to move into talking about the maintenance of SGS Web and some of the challenges that we face with the current application. We're also going to touch on how the next edition of the guidelines, so what we've been talking about all morning, and also how the upcoming parole guidelines that are still sitting out there will impact SGS Web, and explain the SGS Web Next Gen initiative. And lastly, I just want to provide a little bit of information about the Applications and Information Technology Unit. So I will start by passing it over to Ryan to kick us off.
All right, well, thank you, Christy. And it looks like my job's a little bit lighter here, because I think I just take care of the first bullet here on the agenda. So hang in there. I think what my task is really to describe, like what SGS Web is currently, without going into any great detail of the fine mechanisms of the application. So I'll try to do my best to give you sort of the current status of SGS Web, but also with the focus of connecting this to the Commission's enabling legislation and the importance of SGS Web and what it does, for the Commission in fulfilling its mandates from the General Assembly. And then, just as Christy mentioned, to provide everybody, a little bit of an idea of like how do cases flow into the system, so that courts receive guideline recommendations and the Commission's risk assessment information. And then lastly, thinking about how is information reported to the Commission through the application. So hopefully in maybe about 10 minutes or so, I will try to unpack all of that for you at a fairly high level as we go through. So the first thing that you see here is, what is SGS Web and the application, and who is, sort of primarily using it. The focus is for the courts. And I think what you think here is, what are the courts or individuals that are using SGS Web achieving through it? What are the outcomes? What are work products that they have? And their use of SGS Web to fulfill their requirements based on the Commission's mandates and the Commission policies around using SGS Web, around considering the guidelines at sentencing and reporting sentencing related information. And so as I go through today, I'll probably try to say sentencing related so that I don't have to say sentencing, resentencing, parole, and so forth, but just think of the broad package of information that the Commission is looking to collect from counties. So there's 3 things that you see on the screen, these sort of outcomes that I'm talking about. And the court will use SGS Web, 1, to calculate the guidelines. And we'll talk about that, and Christy will, and you've heard Matt and Mark talk about it to some degree. Just the use of the application in generating sentence recommendations. And we put the language here in correct guideline recommendations, just to indicate that the application is programmed based on the policies of the guidelines, which are complicated. You all have been in many of discussions around the policies of the guidelines, and they're complicated, but they're built into the application to support users in finding the correct guideline recommendation. And the second thing that you see on the screen is about the sentence risk assessment. And there's really two things here. One is the access to the risk assessment. You have to use SGS Web to access the risk assessment because it's automated. And then the application generates the recommendation from the risk assessment for the court. So that's building it into the guideline recommendation. And then the final thing that you see on the screen gets to what the courts are required to do, which is report that sentencing related information to the commission. So again, those are sort of three things and three areas that I think of, or that we think of when we're trying to talk about the use of SGS Web by the courts and others, and areas where they're achieving certain outcomes or submitting information to the commission. So let's use that last one about submitting information sort of to jump to the next screen and talk about the commission's enabling legislation. And here you'll see Title 42, Section 2153, and this is the powers and duties of the commission. And this clearly is not all of the powers and duties of the commission, but for our limited time today and sort of focus on SGS Web, we wanted to raise these areas to you. And so the first thing is the commission having this responsibility to establish a research and development program. And in doing so, there's really two areas of that we think about. We think about the commission as a clearinghouse of sentencing information, or a clearinghouse and information center around sentencing related information. And the second part is that the commission can act or does act in this consulting capacity to the courts and other departments, such as the Department of Corrections or the Parole Board, using the information that it's collecting around sentencing. Which brings us to the second part of what's on the screen, and these are related mandates. And again, this is information that the application can collect and ultimately consume, and then produce for you as members and for others around the commission's mandates. And you'll see things like disseminating information on sentencing practices and sentences imposed. Clearly, the commission each year produces an annual report on sentencing information for the state. There's a mandate around studying the effectiveness of sentences and correctional programs. Historically, the commission has on a biannual basis looked at the former state intermediate punishment program, boot camp, and others. The third one here you'll see is monitoring compliance with the guidelines and or sentencing statutes. This is probably relatively new if we think about Justice Reinvestment 2 and the commission's responsibility now to certify compliance with the guideline. So there's other mandates that the commission can work on. And by the application of SGS Web, ultimately having the information necessary to fulfill these mandates. And then the last thing that you see on the screen is this simulation model, this correctional population simulation model to determine resource utilization. And the takeaway for all of this is, look, the commission has mandates from the General Assembly. And one of the ways that the commission fulfills these mandates is through the collection of sentencing related information. And SGS Web is the application that allows us to do that as staff, providing that information to you all as commission members. So we wanted to make sure that, we're going to talk about SGS Web as an application, but that we tie that to the responsibilities of the commission. So here's just, we'll get off of the text and just put up a nice visual for you. And I think for the next few slides, it's really visual representations of how does the application work and the complexity of it. You've heard Mark and Matt talk about the complexity. You heard Christy talk about trying to minimize the complexity in some respects, just briefly. So what I'd like to do is just talk about what all goes into SGS Web to produce various pieces of information for the courts. And I'm not going to go into any great detail on any one of these boxes. I just want a big picture here. And in order to talk about it in the time that we have, I'm going to break it into two areas. And when I train on SGS Web or speak about SGS Web with counties and practitioners, I think in two areas. I think pre-sentence and I think post-sentence. I think that's a nice way to sort of split out SGS Web in the application. So first, let's just look at pre-sentence. The quick takeaway here is there's a lot of modules in SGS Web, and a number of those modules are required to be completed in order to generate a guideline recommendation to the court, to generate a guideline sentence form. And if you start from left to right and you're moving across and you end with the generate guidelines, you can see you have to start a case. There's work that goes into that. There's modules about the individual's demographic information that needs to be inputted. Certainly we have interest and prior record score and offense gravity scores, as Matt and Mark discussed earlier. Those are our primary attributes within our system that give us a guideline recommendation. And then more recently, we have the inclusion of the sentence risk assessment and using the application to walk through all of these modules to ultimately produce a guideline sentence form that includes a sentence recommendation and the sentence risk assessment recommendation. So, just take away that there's a number of modules that an individual has to walk through and interact in order to create a recommendation. And then also keep in mind that the commission has a mandate to generate a sentence recommendation for all misdemeanor and felony convictions coming through the court. So as I'm talking and Christy's speaking about SGS Web today, while we may speak about an entire judicial proceeding or sentencing hearing, at any given point that could include one count, it could include 50 counts, it have one docket or 10 dockets. So, you could see how a simple case coming through with one count and maybe not a prior record score will move through pretty quickly. But as we see cases grow and numbers grow, there's a lot of interaction with the SGS Web application in order to generate one of those forms over and over and over. So there's your pre-sentence part of the module. And then the second part that I wanted to talk about is the post-sentence. And while initially you say, well, hey, that's less modules, true. However, I will say that the entering the sentence information, or the sentence module, is a hefty module. And the reason I wanted to preface that by saying we have a responsibility for all convictions, misdemeanors and felonies coming through the court, that requires the individuals to enter sentence information on all of those convictions, whether they're concurrent or not. So we have a very, beefy module that's collecting a lot of information that again relates back to the earlier slide about enabling legislation and fulfilling all of those mandates. So I just want to keep, us on pace here and turn it over to Christy. I have 2 more slides after this, but I think that gives us, a big picture and a visual of sort of the flow of cases coming through SGS Web. Because we're talking about SGS Web, I think we felt compelled to at least show you something from SGS Web. And here is the homepage, if you will, sort of the landing page of SGS Web, which we, affectionately refer to as the digital dashboard. I think it's a nice visual to say there's a lot of things happening here, sort of the navigational space for an individual as they come into SGS Web. On the left-hand side, you can see how they can interact and find their way around the application. And across the top of the screen in the middle there's different tabs to tell individuals where cases are, sort of where their status is in the flow. And again, we're not going to get into any great detail here. I think the last thing that's important to note is just looking in the middle of the screen, you can start to appreciate the amount of information that is housed within SGS Web. You see docket information, you can see the individual's information, commission information, and then you start to see all of the various modules that are part of SGS Web. So my final slide, and then turning it over to Christy because it's really her show, is the guideline sentence form. And the last thing here is, I think this is a great representation of the complexity of not only the guidelines from a policy standpoint, but just the work that goes into creating this one form, and then again, over and over for however many conviction offenses there may be. And sort of the tour here of the guideline form is going to be brief, but if you think about the top of the form as the individual's information and relating that to the offender module, where the commission's SGS Web application is leveraging some information there and automating things. We see the risk assessment now built into the guideline form. So that's another representation of a module. On the left-hand side, you see the prior record score. The first takeaway is, well, it might not seem so complicated. Well, there's a lot that goes into inputting information here, but I would point to the fact that each one of those blocks has a different way of scoring those offenses. And then that combination of blocks there is scored differently depending on what the current conviction is and so forth. So it helps to automate the final calculation, but you can get an appreciation. It's, almost half of the form itself is prior record score. So there's a lot going into that. And the final two things I'll mention, on the right-hand side, on the top, you'll see the offense information. And here's where I get a true appreciation for just the amount of information going into the guidelines. If you just look, you can see you have the offense information, you have the OGS, you'll have the recommendations, the aggravated, mitigated ranges and all, but you also have the commission's enhancements. And then you have eligibility for programs. I mean, these are all things that are occurring within the system. And then the last thing that you see at the bottom is really the outcome. This is the post-sentence part of it. And, just look at all of the boxes there. There's a lot of information that individuals are inputting. And this represents one conviction offense. So if you have 10 of those, you can see how that starts to be, a lot of information, a lot of work that individuals are putting in. And so as I turn it over to Christy and just connect what Matt and Mark were saying and the work of the academic panel and others, is just to think about from an application standpoint, where we simplify and streamline things at a policy level and how they'll impact the work of Christy and her unit. So there you go, Christy, I'm turning it over to you.
All right, thanks, Ryan. That was great. I'm going to start by talking a little bit about what goes into maintaining SGS Web now. SGS Web is an agency-hosted application in JNet. So hosting it in JNet allows the courts and agencies across the state to securely access the application. However, it's our unit that's responsible for all the maintenance and development of the application. So any changes in policy that impact sentencing or other mandates typically requires some sort of corresponding change in SGS Web, even something that seems rather minor, changing the way something is worded, like the judge authorizes a program versus the judge eliminates eligibility or something, requires quite a bit of changes to SGS Web and its data. So sometimes the change is accomplished by just modifying configuration data, such as adding new offenses or changing statutory limits or OGS assignments. But more often than not, we actually have to make programming changes to the application in order to achieve whatever is needed to support the policy change. And I also want to mention that SGS Web integrates with other state agency systems. So for example, we receive sentence event information from CPCMS, and occasionally they make changes in their system that trickle down to SGS Web that requires us to make modifications in SGS Web. So this slide just lists all the kind of the more significant changes that we've implemented since I've been with the commission, which has only been a year and a half. So just trying to say there's a lot of work that goes into kind of keeping SGS Web current with policy and keeping it running efficiently. So next slide, Ryan. We do have a few challenges with the existing version of SGS Web. The application was originally developed almost 20 years ago, and so it's been through many revisions by many different developers since then. It was built for the specific purpose of sentencing guidelines, so it's really structured around the sentencing event instead of the offender. And that becomes a problem when we start talking about parole guidelines and recommitment ranges, just because we need to be able to look at the sentencing data from a higher level, from that offender level. Another challenge that we've seen is the navigation within the application just isn't very intuitive. Users tend to find the screens and process flow to be a little cumbersome. So if they find the application difficult to use, they may end up, not intentionally, but not entering data correctly or not entering data completely. And as we know, we need that data to be able to do the work of the commission. So the third one, so there are areas like we've talked about before where, like Ryan just mentioned, actually with the prior record score, where we require the user to enter a lot of manual data that we could possibly be populating for them automatically based on data feeds from other agencies like AOPC. And lastly, the technology that SGS Web was built on is outdated, and that just makes it harder to maintain and harder to implement newer features. Thank you. You read my mind. So Mark and Matt spoke earlier about the changes to the sentencing guidelines that are proposed for the 8th edition. And as you're well aware, the Commission is also working on adopting guidelines for parole and recommitment ranges. So I just wanted to note that these efforts will all require kind of a significant undertaking on our part to implement the necessary supporting functionality in SGS Web. The changes that are being discussed for the 8th edition are very different from how the guidelines are calculated now, just that whole step up, step down with the enhancements. So we will probably not be able to leverage existing programming, and we'll have to build a few things from scratch. And then with the parole guidelines and recommitment ranges, since they're all new, we're definitely starting from scratch with those. We're trying to think about these holistically and together, and trying to kind of determine the best architectural approach for implementing this into SGS Web and turning it into more of an enterprise application instead of just kind of a specific purpose application. But Mark mentioned earlier, it is hard for us to start making some of these application design decisions until the policies are kind of more defined and accepted. And then even once the guidelines are adopted, it's a complicated process to build an application. So it's going to take a significant effort to build the functionality, and it'll take time. Next slide, please. So we did recently kick off an initiative that we're calling SGS Web Next Gen. So we keep mentioning the next generation of SGS Web. That's our little short name for it, SGS Web Next Gen. And so what we're thinking is this initiative is going to entail a series of projects to kind of redesign the SGS Web application to address some of those existing issues that I mentioned, in addition to constructing new functionality for the new and revised guidelines. This slide highlights the goals that we'll be striving to achieve with that initiative. So obviously, the first is to redesign SGS Web to reflect the 8th edition guidelines and construct new modules for the state parole guidelines and recommitment ranges. So we're waiting to see what the final version of those guidelines are going to look like. And as we build the new functionality, we plan to modernize the foundational technology and user interface. Web application development has come a long way in the past 20 years. So we will, our team is going to greatly benefit by migrating to a newer development framework. And I think the user will benefit from that as well, just because the application will look more like a modern application. And Matt and Mark both mentioned several times about automating and simplifying the guidelines, which we're hoping that's going to trickle down to the application itself. The user right now has to enter quite a bit of data just to generate the sentencing guidelines before the hearing. So we hope to be able to simplify that process and automate where possible by kind of leveraging data integrations with other state agencies. For example, we already automatically retrieve criminal history data from AOPC in order to calculate the sentence risk assessment recommendation. So we're hoping to be able to leverage that same data for the prior record score calculation. So the user, has to, maybe they might still have to enter some information, but maybe not as much information. Similar to this, when we get to the parole guidelines, we're hoping to be able to integrate with the DOC captor system to also pull some data that will feed into calculating those guidelines. So we believe that by kind of streamlining these processes and reducing some of the pain points for users, there'll be fewer data entry issues, which should improve the quality of the data collected. And the last thing I'll mention is, the existing application, I don't want to talk too badly about it. It's good. It serves its purpose, but it does look very dated and antiquated. So we want to make sure that the next generation of SGS Web, is an enterprise level application, both in functionality and in quality. Next slide. The last thing I'll speak about is the Applications and Information Technology Unit, which is it's the team doing all the work here. Well, this part of the work anyway. SGS Web was originally built by an external vendor, so they developed and maintained the application for many years after the initial implementation. And then a few years ago, the commission decided to move the application development and support to an in-house team. And so that's when the applications and IT unit was born. We're currently a team of 3. So with me as the manager and Steve Adams and Stephanie Kohler as software design specialist. However, to continue kind of supporting this existing application and start working on the next generation of that application, we need to increase the unit's capacity. So we decided a while back, a few months ago, that we're going to add 2 staff positions to the team, a business systems analyst and a programmer analyst. So the business systems analyst will be responsible for the requirements side, gathering and documenting those, and also helping with the other side, like once we implement changes, testing and validating the application, and also investigating users, issues reported by users. And then the programmer analyst position will initially be focused on maintaining the existing application, researching and correcting bugs in SGS Web, and performing routine system administration tasks. But then that person will also eventually become more involved in the next gen development. And I am happy to say we filled the business systems analyst position. We'll have Tim Wilson joining our team in July, but we're still hiring for the programmer position. So if you know any programmers, let them know about the position. That's all I have. Is there anything you wanted to add, Mark? I was trying to get through it in the time because I know we're getting close. So
no, well, first, that was incredible to you and to Ryan. Thank you very much for that. As a reminder to commission members, whenever we talk about adding staff or additional resources required, it means budget and financing. And one of the things the commission worked on over the years was to try to build into funding through the JRI 2 initiative, funding to support this effort. And so, as you may recall, JRI 2 provided a $400,000 a year for 4 years that was intended to be used to bridge the gap, provide this additional capacity, and build us towards a point where our appropriation could catch up to provide this capacity we'll need to not only build this new application, but to do it while running an existing application, and then at some point transition over to the new one. It's a lot of effort, a lot of work. We think we can do a lot of it with this expanded in-house team. We may need to do some external consulting on architecture or other things like that. It's a big project, but we think we've done it responsibly in terms of linking it to the JRI funding. We think that will really help us. And as many of you know, we've also identified some funding that we have from reserves that we have targeted as necessary to use to make sure we can move this project along. And to that point, one of the disappointments this year is that the JRI funding, our first year of funding, looks like it may not exist just because of COVID and everything else. And so fortunately, we do have reserves that we can use to fill that gap. But we have strong expectations and really a need to make sure we have the other 3 years of funding or funding beyond that to make sure that we can fulfill this need for a mission critical application. So with that, I know we're about at the time of the end of the meeting. I know Judge Tucker has to move to another meeting. Just to let you all know, we're going to actually take a break between this meeting and the commission meeting, and we anticipate the commission meeting will start at 11:15 instead of 11:30. So plan to be back by then. I'm going to turn it over to Judge Tucker in case he has any closing comments.
That's it. Thank you very much for all staff who participated in the wealth of information provided. So we'll adjourn until 11:15.